hour. Oops, let me just say, got it. I'm going to try to give you everything in the hour. I just want to be respectful of your time. But I want to share this really interesting subject of copyright with you. A lot of the time people think it's not particularly interesting or it's really hard, and I'm going to do everything I can today to make sure that that is not the case. So let me go ahead and share my screen. And if you do have questions, kind of pop them down. You can pop them in the chat, but I won't look at the chat until we get to the end. Or just hold on to the question and I'll have time at the end after the recording is over. So let's just go ahead and get started. So nau mai, haere mai, ki tēnei hui whakahere. Ko Karen Workman tōku ingoa, ko taku mahi ki te manu taroa Aotearoa, ko te kai whakahaere whakapa. So nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Today's workshop is presented to you by Copyright Licensing New Zealand. We've been supported by Manatū Taonga, Ministry for Culture and Heritage, and it was developed because we really recognize this need for people in the creative industries to properly understand their creative rights or copyright. I am not a lawyer, so it's not legal advice. I'm also not your lawyer, so I can't help you out there, but and I don't know everything. So copyright's a really big subject, but we're going to go through foundational material today based on the New Zealand Copyright Act, which is what we are under here in this country. I will give you a ton of information. So if you don't catch it all, I think you can go back to the recording or you can ask me questions. If you have a specific question that I don't answer, please feel free to email me anytime at the address that you see down here for copyright questions. And Catherine has and Sharon have my email address as well, so you can get me in any way. Just a little bit about me. Professionally, I've performed and recorded as a classical pianist, an accompanist, and a songwriter. I have written and self-published a book. I married a rock guitarist and recording engineer. The last 10 years or so have been spent living in Hollywood with our family. And 3 out of the 4 of my kids are actively in the screen industry. So, and I've been involved in some production work and so on. So for for my whole life, really, I have been involved with directors and composers and writers and artists and so on pretty much every day, especially now. So for us, rights is a big deal. So when we hear about copyright in the news, we tend to get fired up, but like a lot of you probably, our knowledge is based on what we heard or what we think is right or what we've seen on social media, not on the actual law. And so what we're going to do today is to try to take away some of that anxiety and some of the lack of confidence we have around navigating copyright. So this little symbol was first used in the USA from 1909. It was adopted internationally in 1955. And when you follow it with a name and a date, it tells everybody who owns the copyright to that particular work. And copyright literally means the right to copy. Now you're going to hear me say creative rights and you're going to hear me say copyright. And I mean the same thing with both those terms, because what you'll find out is that copyright is actually a bundle of different rights that we have that's all wrapped up in this law. So we're going to focus, as I said, on New Zealand copyright law today. That's the Copyright Act of 1994. You might already know that it's well overdue for a review. It has been updated since 1994, so it's not that old, but there's a lot of changes and a lot of things in the wind. So, it is going to come up for reviews probably within the next couple of years. So we'll keep an eye on that space, but everything that I tell you today is good information. There just might be some changes in the future. Now, our copyright law is based on what was established by the Berne Convention in 1886. That's the international agreement that governs copyright. Now, there's about 181 different countries that are members, and so we all start from the same place. And that's why copyright applies to us no matter where in the world we happen to be or where we create our work. But the way that copyright law gets fleshed out and built upon could be different from country to country. And we'll talk about some of those differences. Just to get us started here, there's several different kinds of protection for intellectual property, but these are the big 3. So trademark, that's whatever distinguishes your brand. So it could be a logo, could be a catchphrase, it could be anything to do with branding that makes your company distinguishable from another similar company. So if I said Golden Arches, We all know that that is a trademark for McDonald's, not for Burger King. If I said to you something like, it's moments like these you need, we all say Minties. I think we all say Minties. Sometimes people don't know that one, but it's Minties anyway. And that's a catchphrase for Minties. So that's what a trademark covers. So it's logos and catchphrases and branding. Patent or patent, that protects process. So we're talking about new inventions, we're talking about new designs, we're talking about, and it's designs for things like an object, a functional object, for example, like a folding chair or something along that line. It could be a scientific process or a discovery of some kind. That's what patent protects. Now, trademark and patent both have to be registered and filed with IPONZ. That's the Intellectual Property Organisation of New Zealand. But copyright, which applies to creative arts, does not. Copyright is completely automatic. There's nothing you have to do for copyright protection to exist. Now let's have a look at what these three protections look like in one object here. You can see the swoosh in the middle, or the tick mark. That's the Nike. That's a trademark for Nike. We just know it's Nike. Nothing has to be said. It doesn't have to have the word Nike on it. So that's a trademark. The technology or the process created to pump air into the shoe, that's protected by a patent. And the design and the colors and the choice of materials and so on, that's all covered by copyright. And there may be some design rights in there as well. So today we're going to focus on this copyright. Now, intellectual property is in some respects like physical property. It can be sold, it can be transferred, and it can be inherited. So we want to protect our property because it has value. And in fact, copyright law wouldn't exist if there was no value in our artistic work. And we're talking not just about your social value. So we entertain, we teach, we inspire, we preserve records, we provide representation and so on. That's the social value. But you also have financial value in your work. And when you know your rights and you can protect that creativity, it's much easier to tap into that financial potential. So basically our work has value because other people want or need it. And copyright law exists to sort of balance that out, balancing out the protection of you as a creator alongside the protection of the wider community and being able to access the work that you do. So what exactly does copyright law apply to? Well, it's anything that meets this definition. So it's a new and original work in a fixed and tangible form by an identifiable creator. And for us in Aotearoa, it can be physical or digital. It doesn't make a difference. Other countries make a distinction between physical work and digital work. We do not. The categories underneath this definition here cover just about everything in the creative space, I think. Literary, that's your fiction, your non-fiction writing, obviously, but it's also things like academic writing or business plans or song lyrics. It can even cover emails, and it definitely covers computer coding. So that's all literary, text and numbers. Musical is your sheet music and your written notation. So it's your chord charts, your lead sheets, and your scores. Artistic is everything in the visual arts realm that is static, so it's not moving. So your photographs, paintings, sculptures, diagrams, models, sketches, engravings, all of those things come under artistic. Dramatic refers to screenplays and scripts and so on. So it's the show, but it's been written down. So it's a scripted thing. It also covers choreographic notation, in case anybody here is a choreographer. If you've got it written down and somebody else can reproduce it, it is actually protected under dramatic. Sound recording and film is exactly what it sounds like. It is recorded sound and moving pictures. So any kind of recorded sound, doesn't have to be a song. It could be a chair squeaking or a dog barking. And film is everything that's moving. So it's your animation as well as your live works. And it doesn't have to be a film. It could be a music video or a commercial or a TV show or anything along that line. And then publishing refers to the typographical setting of work to the public. So that's when we're publishing a book, for example, and we're talking about the font choice or the layout or the page numbering, all of that sort of thing is covered by publishing. Now, many of us are working on ways where there's copyright protection for multiple aspects. For example, if you've got a children's book, you'll be covered under literary for just the words, artistic for just the illustrations, and publishing for the actual publishing of the book, the layout, and so on. And even performance work can use multiple aspects, from music to backdrops, which would be considered artistic, programs, which might be literary, recordings of the actual performance, and so on. So you can see with one thing, we might have lots of different aspects of copyright protection. What's important to note is that copyright doesn't protect ideas and concepts and facts. So you can't copyright something like an artistic style. You can't copyright something like a joke form or a game show format. You can't copyright a general plot. And it's very, very hard to protect a shape. You also can't copyright a recipe. And that's because a recipe is a list of ingredients and then some simple instructions, which are called facts. So it's very difficult to copyright a recipe. It can be protected under a trade secret if you've got your 11 herbs and secret, whatever it is, secret herbs and spices, but not under copyright. A recipe book, though, is protectable in terms of the publishing aspect of it, but the facts of the recipe will not be protected. What is protectable is the expression of those elements, or the way that these ideas are presented. So if you think about how many films or books have the same basic story, but they've got different characters and different place names, different settings, and so on, lots of variation, so much variation, it's like a completely different story. So just to reinforce this, ideas are not protectable by copyright. It's the way that they're expressed that is protectable. And let me give you a real example. You might recognize this as a trademark for Nike. It's called the Air Jordan or the Jumpman logo. And it's got a really interesting backstory. So Jacobus Rentmeester was the photographer who shot this image for Life magazine to showcase the Olympic athletes of 1984. Now, he brought that hoop into this location. He made creative decisions about the exposure and the angle and so on. And then he also directed Michael Jordan to strike this pose, which is a little unusual. It's more like a grand jeté from ballet than it is a basketball, something you see in a basketball game. Well, Nike saw that image in the magazine and paid Mr. Rentmeester $150 for a license to use it exactly as we are right now. Slide presentation only for in-house use. And shortly after that, Nike hired a photographer to shoot their own photo of Michael Jordan. And there it is. It showed up on billboards and posters around North America. And when Mr. Rentmeester saw it, he threatened to sue Nike. So they came to an agreement, and Nike paid him $15,000 for 2 years to continue using their own photo on billboards and posters and so on around the country. And during that time, they created the silhouette logo. And I think you can see which of those photos the logo is really a silhouette of. Now, Mr. Rentmeester came back later on and filed a lawsuit, and he claimed that both the logo and the photo infringed on his copyright. Now, remember what we were just talking about. The main concept or idea in the original photo is Michael Jordan leaping through the air in that pose. So, knowing that concepts and ideas can't be copyrighted, so the idea is him in that pose, and the reason that is a concept or idea is because maybe not me, but maybe Sharon could go out there and strike that pose on the basketball court, and we could all take a picture of that. So that pose is not copyright protected. Michael Jordan is a person, so you can't really copyright a person either. But let's have a look at how it's been expressed. So we've got to look at things like the location. So we've got a grassy hill in one, we've got a cityscape in the other. So location is different. How about the lighting, the color, the angle of the camera? All of those things are not the same. So the way that this pose has been expressed is substantially different. And so when this went to court, the court ruled that this was not a copyright breach. And the logo is based on the Nike photo. And so that doesn't breach Mr. Rentmeester's copyright in his original work either. Let me show you a literary example. Let's say, and if you're a parent or a child, you probably know, I'll give you a plot line. It's a story about a dog who travels around the country or through the country looking for the family that he got separated from. I can think of about 5 or 6 at least different films with that idea. Now, if I said that to you, you and I would write that story in different ways. We might have different locations, different character names, different towns and so on, maybe different plot points. But each of these works is going to have its own copyright protection because the expression is original. Now, that means that one author didn't copy the other. So both of these stories can exist legitimately in the world because they were created independently and they express this idea in different ways. So originality doesn't mean creating something that's never been done before. It means that you created it on your own without copying somebody else's finished work. So if you've got something that falls under this definition, your work is automatically protected by copyright. I'd just like to sidestep for a second here and acknowledge that some creative work doesn't fall neatly into this definition. And we're really talking about work of traditional knowledge or indigenous knowledge because it may be lacking in terms of this definition. They may be building on past work or sharing, so it may not be considered original or new. It may not be in a fixed or tangible form. It might be an oral history or a song or something that's not been written down, or it changes all the time. It may have been created collaboratively or over successive generations, so there's no identifiable creator. And maybe there's no concept of ownership within that culture. So if we've got any of those conditions, these works don't fall under the protection of copyright. And in the absence of that protection, it's just up to us as creatives just to guard and respect that work, just by asking, is it my story to tell, or do I have story sovereignty? Do I have the mana to use all those cultural elements and so on? And we might need guidance around that. That's because when work is culturally appropriated, particularly for financial gain, there's not much guidance, there's no legal path, and there's often no real consequences. And it's not a New Zealand specific challenge. It is all over the world. There is work being done to strengthen the respect and protection for Indigenous knowledge. But as you can see in this particular case, we're not there yet. Australian Aboriginal artist B.B. Barber had painted a series of works relying on elements of cultural significance. She Googled her name in 2012 and discovered that a designer for a hotel in Poland had created all kinds of objects and furnishings based off her work, as you can see here. So she pursued the hotel with copyright claims. It's my understanding she escalated it to a human rights issue, but there's been no resolution. So as I say, there's things being done, but we're not there yet. Where a work of cultural significance does meet the definition, it does get the same protections as other artistic work, and legal action can be taken, as in this case right here, which I'll refer to again later on. There is some protection when things are trademarked, but it has to be that particular thing that is being protected, not just, we can't say, oh, this koru is trademarked. It's only that representation of a koru shape. It's not every koru that is protected. However, we have Te Tiriti, particularly Article 2, pertaining to Te Tino Rangatiratanga or Te Iwi Māori, the chieftainship of Māori over Taonga. So we've got an added cultural responsibility to be a little bit more considerate and educated in our treatments of cultural significance. So let's talk about the characteristics of copyright. So as I mentioned already, copyright is automatic. It's protected the moment it fits that definition. Nothing has to be done. There's nowhere to register. There's no national or official place to do that in New Zealand. There is in other countries, and those different countries have different purposes. If your work, for example, is going to be used in the US or show up in the US, you have to register your copyright there before you can sue somebody. So copyright protection still exists, but as a part of the legal system, if your work is not registered with the Copyright Office in America, you can't sue somebody over there. So that's why. There are different purposes, but we don't have anything. With all of the countries in the Berne Convention, nothing has to be done for copyright protection to exist. Just as so you know too, you don't have to have the copyright sign on it to be copyright protected. That's not a requirement. Putting it there tells everybody that you own the copyright to that work, or that somebody owns the copyright to the work. So if you're somebody who is looking around for work to use, if you don't see a copyright sign on something, don't assume that it can be used. You still have to try to track down the copyright owner and to make sure that it is usable by you. A limited time. I'll talk a little bit more about this later on. For right now, I'll just say, for right now, your copyright protection is in place for your entire lifetime, plus 50 years from the end of the calendar year of your death. It is going to go up to 70 because we've had these free trade agreements with the EU and the UK, but at the moment it's your life plus 50. And exclusive. So the protection of creative rights is exclusive to the copyright owner. Now, when you create your work, the rights belong exclusively to you. So that makes sense. So when the paparazzi take a photo of a celebrity, they own the rights to that work. And that's why celebrities like Dua Lipa, Justin Bieber, Khloe Kardashian, LeBron James, who screenshot and repost those photos without permission from the photographer, are being sued $150,000 for publishing an unoriginal photo without permission. So it might seem unfair that celebrities can't repost a picture of themselves, maybe, but the law is clear. It's protecting the artist's exclusive rights to that copyright. Now, there are two specific situations in which ownership of copyright doesn't belong to the creator, and that brings me to the commissioning rule. So this is the passage in our Copyright Act that outlines the first ownership of copyright, and it basically says that if you're the creator, all of the creative rights belong to you unless you did the work in the course of your employment, so inside your job, or if somebody commissioned you and paid or agreed to pay you for the customized work. And one thing to be aware of is that payment for work doesn't have to be financial. So if there's an agreed upon exchange of some kind, for example, if I said, I want you to paint a mural for me and I'm going to give you supplies like paint or travel or accommodation, then I am the person who commissioned the work and I've paid for it in some way. And by that law, I own the copyright to it. So, you know, if you're a photographer or an architect or a designer or a choreographer or a studio musician or a ghostwriter, you'll know that you often do work for hire. In other words, you've been hired to do something creative and something specific. So if you're employed to do that or commissioned to do that, the copyrights to that work stay with the person who employed or commissioned you. Now, that is what the law says, but you can change this default law by having a contract or an agreement of some kind where you agree on the terms of your engagement. For example, my employment contract acknowledges that I create work that's unrelated to copyright license in New Zealand on my own time and that's mine. You might have a contract with a commissioning party that assigns the copyright ownership to you. So then you have the right to make and sell copies of that work that was commissioned. They might have asked you, if it was in our case, I might have asked you for this mural, but you might want the right to use that image to create t-shirts or calendars or something like that. So you would have a little clause in our contract that says, I retain the rights, I retain full ownership of the copyright of this work. So that would be part of our contract. So again, this commissioning rule is the default law in New Zealand, but you can change or modify that. I want to touch on this because it is such a hot topic right now, and you might already be in this space, and that's work generated by artificial intelligence. Now, technology is really changing, and AI is generating work in all kinds of new ways. What you see here on the screen is 2 books of poetry co-authored by a human and ChatGPT. I think it's pretty clear that we're going to need some legislation or regulation around this technology, and I think that's on the cards. But for right now, what the Copyright Act says is that the person who creates a work shall be taken to be, in the case of a literary, dramatic, musical, or artistic work that is computer generated, the person by whom the arrangements necessary for the creation of the work are undertaken. That's a very long way of saying that for a computer generated work, our law currently indicates that the person who put the prompt in or put in the parameters to generate that work is the copyright owner. Now, other countries are wrestling with whether an AI generated work even has a copyright owner based on their definitions of what's protected by copyright law and a bunch of other considerations. As far as AI generated sound-alikes is concerned, there's nothing that prevents those from being created, but if you try to pass it off as the real artist, you're likely to get into trouble. And that's sort of where that's sort of the line there. But in the US, you can see that bottom right image right there. The Stephen Taylor created this image using his own algorithm and then applied for copyright registration on behalf of the machine, listing the AI as the creator and himself as the owner. But it was decided in court last month, I think it was, that copyright has never been granted to a work that was absent any guiding human hand, and so AI-generated work can't be copyright protected. There's going to be a lot of discussion about this. You might already know, you may already be using AI for things for your work, but what we need to know really is that in New Zealand, it doesn't really matter how the work was generated. If you generated it somehow, then you are the copyright owner. If we have if we have authors in here, we can talk a little bit more about how that's working right now in terms of proving ownership and all that kind of thing later on. But I just wanted to let this is a watch this space kind of time. And there are really big questions around the human input or human endeavor aspect to it. Okay, so let's jump now to what copyright actually is. As I said, it's creative rights. It's actually a specific bundle of rights belonging to the creator, and they are moral and economic rights. Now, moral is everything to do with who you are as an artist. Economic is everything to do with what you want to do with your work. So I'm just going to go through each of these briefly. The first moral right is attribution. This is the right to be known as the author of the work. And that sounds pretty obvious, but it has to be in writing somewhere. So it should be with your contracts, with your copyright notice, it should be on your book, it should be on your website, it should be beside your artwork, that any use of that work, so that any use of that work can be accompanied by a specified name for you. You can use your real name, or you can use a pseudonym, you can use a group name, you can use whatever you want, but it has to be in writing. And we have to be able to identify you at the other end of it. But that one's pretty clear. Our second moral right is the right of integrity, which is also known as the right to object to derogatory treatment. Now, this goes beyond getting a bad review. This is manipulating an original work in a way that harms the reputation of the original copyright owner. And by reputation, I'm not really talking about how nice you are. I'm talking about the thing that you're known for as an artist. So in this particular case, the Air Pirates were a group of artists who were Mickey Mouse antagonists. So they created and published 3 issues of this comic book. They drew the Disney characters doing very R-rated things, so don't look it up. It will destroy your childhood. I'm not sure if you can see it in the illustration there, but the villain is holding a bag that says dope that he just stole, or that they just stole off Mickey and Minnie. This treatment made the Disney company very unhappy. So while this case was taken to court on several different aspects of infringement, part of the case was Disney's objection to the Air Pirates drawing the characters in a way that changed the original work and had potential harm to the reputation of Disney. And that reputation was as a family-friendly company. So that's what I mean by reputation. It's not really about whether you're good operators or whatever. You may be an artist who only uses blue, or only paints in blue, or never uses anything but recycled materials, or only creates music in the key of G. All those kinds of things. So it's about your artistic reputation, not about your character. Character can play into it, but this particular law is about your artistic reputation. Oh, just so you know, Disney did win. It took them 10 years and they made $0 off this one. They didn't make a penny. False attribution. Let me introduce you to Carl Sim if you don't already know him. Born in Mangaweka, died a folk hero, a master infringer of the right of someone to not have a work falsely attributed to them. In other words, he painted the works you see behind him and more, and then he signed other artists' names to them. You might know this practice as forgery. And so he created those works and then signed Rita Angus, Toss Williston, Colin McCann, Renoir, C. F. Goldie, a lot of other artists' names. So if you create a work and sign someone else's name to it, that's false attribution. And just so we know the end of this particular story, he did get caught, partly through evidence of document forgery, which he had created to establish fake authenticity or provenance, but also because when he signed the works, sometimes he spelled their names incorrectly. So just so you know too, he did get punished. He's one of the only people who actually got punished for copyright infringement in New Zealand. He was not fined the maximum. The maximum is $150,000 or 5 years of jail, but he was fined $1,000 and then made to paint the town hall and public toilets in Foxton. So next time you're driving through Foxton, spare a thought for Carl Sim and the right of somebody to not have a work falsely attributed to them. Just so you know here too, these 3 rights that I've talked about also apply when a work is performed. So the performer has the right to be correctly identified and not have changes done that harm their reputation. The last moral right here is the right to privacy. This is the right to not have the work communicated in the public space if you commission a photograph or film for private and domestic purposes, even if someone else owns the copyright, which is basically if your friend's wedding photographer or videographer wants to post pictures of you on their website, you have the right to say no, or to ask them to take it down, even though you don't actually own the copyright to that work. So it sort of fits, but it's not really for the creator. It's for other people. Here's what the Copyright Act lists as economic rights. And I'm not going to run down each of these, but I will read them out. It says that you can copy, issue copies, perform, play, show, communicate, adapt, and authorize somebody else to do all of those things with a copy protected work. Now, this is what the creator can do. I like to loosely refer to them as the 4Ds because this summarizes the ways that a work can be used. And this is where your financial potential primarily exists. So just to note, when a copyright owner dies or sells a work, the economic rights still belong to whoever the works have been left to. So moral rights don't get reassigned, but economic rights do. Moral rights don't get reassigned, but economic rights can get reassigned. So they will travel with the work to the beneficiary, including for unpublished work. That's not the case if you sell a work. If you sell a painting, you've sold the object, but you retain all of these rights. So let's go through these. Duplication literally means making how. It's scanning, photography, any kind of reproduction, forwarding an email, file sharing, copy pasting, taking a sample. It's taking the original and duplicating all or a part of it in some way. Now, one exception is titles. So in the literary and musical worlds, titles generally don't get copyright protection because they're not considered long enough to be completely original. And that's why there are, we're coming up to Christmas, so I'll use this example. There are at least 177 copywriters for the duplicate title of All I Want for Christmas Is You. So duplication is the most commonly understood right in our bundle of creative rights, and usually the way that we discover that something has gone wrong. Our next D is distribution. Only you have the right to rent out or sell your work, and this is where the financial potential of your work lies. Now, obviously, we've got lots of other avenues for income, which is part of the reason that you're in the Wayfind course right now, as well as physical and digital sales. We've got all these other avenues, but they all rely on the ability of somebody to copy and recreate at least a portion of the original work. And unless there's some kind of agreement in place with other people or organizations, only the creator has the right to distribute their work. Display is pretty straightforward. It's your play, your song, your art installation, your book promotion. Only you have the right to publicly perform or otherwise communicate your work. And that includes putting it on social media. Derivatives or adaptations. This is where stuff gets really interesting. This is making new work from an original in a way that doesn't substantially change the expression. So it's basically any new work that clearly ties back to an existing one. So a derivative work could be an audio book made from your original book, could be a new arrangement of an older song, it could be taking your book and turning it into a screenplay or vice versa. It's any other work that is directly originating from the original. So translations also, or your visual art could be used to make a series. These are examples of new works made from the original, and they pretty much have the same meaning or message or vibe, oftentimes the same expression. If you jump back to when I was talking about our two different stories, how they're expressed. And the copyright owner is the only person who can make derivatives. Nobody else can. It's really problematic to use somebody else's work in a derivative way without permission. I'll give you a visual example right here. Judy Juracek is the designer and photographer who published these books that you see on the bottom right there. Those books have photos of various surfaces, and they serve as a visual research resource for artists and architects and designers. So it's there as a reference. So you can look at the pictures and use them to understand things like coloring or artistic detail and shading and those kinds of things. But to use them commercially, you need to contact her for a license, which is exactly what Capcom didn't do, and then used more than 80 of her photos in their games Resident Evil 4 and Devil May Cry. So, of course, this went to court. Judy Juracek's lawyers were asking the court for up to $12 million in damages on account of copyright infringement. But you can see that their use of her photos was not particularly imaginative. They took a photo of a door and they put it in the game as a door. And then they took a photo of cobblestones and used it in the game as cobblestones. So nothing changed, nothing at all. So that's a pretty indisputable copyright breach. This case did get resolved at the beginning of last year. I'm pretty sure she could probably afford to take a little holiday in Europe somewhere because this copyright breach is indisputable. So unless you have permission, duplicating someone else's copyright material, regardless of where it's found, because I've had people say, oh, if it was in a book versus was it online, it doesn't matter. Where you find it, it's copyright infringement. Now, as artists,
Karen, you're frozen. Guys, is Karen frozen for you as well?
has the material taken from the original work been transformed by adding new expression or meaning? And was value added to the original by creating new information, new aesthetics, new insights, and new understandings? Now, just so we're clear, the word transformative isn't in the New Zealand Copyright Act. I'm using terminology that is common around the world, but the principle of this does still apply in New Zealand. So what we're looking at is that a transformative work is expressing something in a different way than an original work. And if it is, and if it's different enough, it's protected by copyright since it's considered new and original. Now, this is a case that the US Supreme Court decided on just a few months ago. The short story is that photographer Lynn Goldsmith took the photo that you see on the left of the musician Prince and licensed that photo to Vanity Fair magazine way back in the 80s. And they were using it as an in-house artist's reference, and that in-house artist was to make one illustration. And it wasn't until Prince died that a different magazine published what you see on the right-hand side there. And Ms. Goldsmith, the photographer, discovered that the in-house artist of 1984 was Andy Warhol, and he'd made not one, but 16 different works based on her photograph. Now, we can look at these images and make our own conclusions about whether they are derivative or transformative from an artistic perspective. So we could compare measurements, we could look at the arrangements, we could look at the colors, we could make a value judgment on how similar they are from our understanding of art. And you and I can look at the original on the left and then the images on the right and say whether we think that they are derivative or transformative and justify that judgment from an artistic perspective. And when you see copyright cases in the news, that's where a lot of the reporting leaves us. And if you were following along with any of Ed Sheeran's cases, you will have seen lots of people making comparison videos of how one song is like another song and trying to decide whether one had been copied from the other and so on. And that's from an artistic perspective. But from a legal perspective, deciding if it's a copyright breach is going to take into account a number of different is going to be artistic similarity. But there will be other things as well, like the nature of the work, what it was used for originally, whether it was for commercial or non-commercial use, how close was it? Was it a significant part of the work that was copied, or was it like, whatever? So we're going to talk about all of those factors. And when they took all of these factors into consideration, the court decided that what you see on the right is not transformative. And that's because the purpose of the art was the same. Both works were to portray the musician Prince in a magazine. Now, by deciding the case in that way, the court avoided making a judgment call on whether it was derivative art based on the similarity of the artwork to the original photograph. So, but not based on the artistic similarity, but based on some of these other factors. Why that is good is because these kinds of works are most likely fine because it has a completely different purpose than the original soup can label. Here we're making a comment on an everyday object, but the original object was telling you what was in the can. I hope what you can see is that it's quite controversial. It is a little bit difficult to navigate. When things are really close, there's no clear line that says something is a derivative or a transformative. It's going to come down to a judge and a jury weighing up all of these factors and making that call. So the more original your work is, the stronger the protection. If you're a writer, this is one from the literary world where Steve Vander Ark, who was a Harry Potter fan, created a website with the material was basically just taken directly from Harry Potter books and films, and it was descriptions of characters and places. He had an idea one day that he would just print out the website into a book and publish that, and people could buy the book. J.K. Rowling objected, of course. She says she was intending to release her own encyclopedia, and that whole idea got shut down before it even began. So how does the book that you see here exist? Well, Mr. Vander Ark got around the problem of derivatives by publishing this book, which is called An Unauthorized Guide to Harry Potter Fiction and Related Materials. Now, the magic word there is not the word unauthorized. The magic word is guide, because a guide to other literary works is an instructional book, and it's got commentary and analysis. And because it adds some value and a new perspective, it's considered transformative. So that gives us an overview of what rights are contained in copyright. But as I said earlier, we're trying to balance out the protection of the creator with the ability of users to access the work. So what's in our law for that to be possible? Well, first of all, we can use work that's no longer protected by copyright law. And common knowledge tells us that we can use a work in the public domain. Now, most of us are really familiar with that term. It's an American term, and it's a little bit misleading. In New Zealand, the term we are supposed to use is out of copyright. And that's because that means that a work is no longer protected by copyright law, and anyone can use and exploit it however they want to. But I want to stress that when we're talking about copyright, public domain does not mean that the work is on the internet or that the work is now visible to a wider audience, okay? So widely available is not the same as public domain. I've heard people say it's on Instagram, so it's in the public domain, but that's not true. Being public domain or out of copyright is when the original copyrights have expired. That's the limited time that I talked about earlier that was given to you automatically when the work was created. So this is how long copyright belongs to the original owner in New Zealand for various categories of work. As I mentioned earlier, some of these terms are going to be adjusted in the next few years. Now, there's no one place to check, so you have to track down the original creator or copyright owner and do the maths to find out if something is still under copyright protection or not. When it's out of copyright, it is fair game. So last year, and the copyright day is always January 1st. So on January 1st last year, it was the first book of Winnie the Pooh that came into the public domain or was out of copyright. And so there were a number of works created, including the horror film Blood and Honey, I think it was called, using characters from that first book. Now, I haven't seen it, but if you watch that one, you'll find out that Tigger is not in it because Tigger is not in the first book, so he's off limits. At the beginning of this year, it was Sherlock Holmes. So now if you wanted to make a movie from a Sherlock Holmes story or just plain old record the book onto your voice memo and then sell that as an audiobook, you can do all of those things without asking for permission from the author's estate, and it's not a copyright infringement. Now, you can also put your work out into the public domain before the rights have expired under a Creative Commons license. And you can also find work under that framework as well. You can see on the left-hand side, there's 4 icons. They mix and match to give you 6 different licenses to tell users what the terms of use are. Now, this is preemptively granting a social license for use, where users don't have to ask for permission and they don't have to be concerned about legal infringement. But I want you to note that Creative Commons is not law and it's not a legal entity. So this is just a socially acceptable or socially understood framework. It's not part of anybody's legal system. Now, I'm all for sharing art and information, and I think there's value in this construct. I just want you to think about how much control you want to have over the way your work is used, because if somebody uses your work in a way that you don't align with or makes money from your work that doesn't go back to you, there's not a lot you can do about it. So copyright, you can see at the bottom of the chart, giving you complete rights so that you can make a living and so that you have a choice over who gets to use your work. I just wanted to throw this up here too. One myth about public domain or being out of copyright, or the internet actually really, is that if you put your work on social media that you lose copyright ownership and anyone can do whatever they want with your work. This is just a reminder that social media and the internet might be public platforms, but using them doesn't mean that you give up ownership of your copyright. And if you go to the terms of service for all your social media, that you'll see that there are clear terms about the content you post. So there's usually a statement that says that you retain ownership of the material you create, but by using or publishing on these platforms, you are giving those platforms a license to do various things with that work. And that's because they rely on the ability of people to share what you've posted. So having said that, if you post something, other people can share it, and once it's out there, it's out there. So be considerate about what you want with your work. But social media and the internet, that is not public domain. So just again, it just means when those rights have run out, because rights are in for a limited time. Now, there's also provision to be able to use copyrighted work before it's in the public domain. And a lot of the Copyright Act is devoted to acts permitted. And that means what you're allowed to do without infringing on the creator's rights and without asking for permission. So we have some exceptions to here. And the way you want to think of this is that the rights of the creator are exclusive to them, except under these conditions. So first we have research, study, criticism, review, and reporting. Now this part of the Copyright Act allows for places like galleries, libraries, archives, and museums, and so on to copy a work for preservation. It allows a teacher to share information with students. It allows you to make one copy of something so that you can use it for your own personal study. It allows somebody to publish a review or a comment about a work and to broadcast it on the news and so on. There's very specific laws that govern all of this, but done correctly, it doesn't require asking for permission. Now, these uses right here are also known as fair dealing in New Zealand. Now, fair dealing tells us explicitly what we're allowed to do. You might be more familiar with the term fair use. Now, I've heard that all over the place, and I want to stress that's an American term, and we do not have fair use in our current law. So fair use is an American defense term, and it's used when somebody's been accused of copyright infringement, and yet they're basically saying, I'm defending my use because it was fair. And that defense really relies on proving that a work was transformative. In the US, fair use also includes parody and satire. We don't actually have provision for that under our list of exceptions. Do we use parody and satire? Yeah, all the time. But because we tend to not sue everybody, it sort of flies under the radar. But just so you know, it's technically not something we have an exception for. So again, fair use does not exist for us. Insubstantial amount is our next exception. So work can be used without permission if it's an insubstantial amount. I'm not talking about a percentage. It's not. It's got nothing to do with numbers or minutes or pages or anything like that, or changing 10 things. It's talking about what's of substance. It's the thing that makes the work significant. So in that photo of Prince, the thing that was significant about that photo was his head or his face. If we'd taken a photo of his, taken a piece of his arm and used that, that's not significant. So that would be insubstantial. And a musical example I can give you is the flute solo in the song Land Down Under by Men at Work contains another song in there, and it's just the 10 notes from Kookaburra Sits in the Old Gum Tree. That is the section of the melody that is most instantly recognizable from the Kookaburra song, and so it's considered substantial. So when this case went to court, EMI, that's Men at Work's record company, now they have to pay Larrikin Music, who own the copyright for Kookaburra, 5% of the royalties because they use that piece of substantial material without permission. So now they have to pay for it. Obviously, one anomaly is fan fiction or fan films. That's where fans are creating derivative material using substantial material like character names or place names and so on to tie their work to this universe that's been created by somebody else. Now, clearly those works are both derivative and using substantial material. Often, but not always, the original creator will tolerate and not prosecute fan works because they're building the audience and providing material that kind of keeps that community running. But it is actually copyright infringement to create fan material. Incidental. So when a work shows up but it isn't the main focus, like a sculpture on a coffee table or a painting on the wall of a real estate photograph, or someone with a sleeve tattoo walking through the background of your documentary, those are all incidental. So there's no commercial value from the appearance of that artwork. It's not really important. The artwork isn't important in that context and so on. So These are the exceptions. So we've got your fair dealing, we've got insubstantiality, and we've got your incidental or transient appearance of that work. I will mention this too right here, because it's a bit of an unusual exception based on the art itself. So Mr. Radford, long story short, had sculpted these three architectural forms that they're now in a public park. Sometime after it was installed, Helen Steins commissioned and sold T-shirts and printed with a photograph of these forms and some graphics on there, and it went to court for copyright infringement. Now, this course was problematic for a number of reasons, but and it was settled outside. But what it does is it reminds us that in Section 73 of our Copyright Act, sculptures in public places, or sculptures that are permanently displayed in public places, can be photographed or copied into 2 dimensions, and you can profit off those copies. This is the same treatment of sculptures as of buildings. So that's the law that allows you to take a photo of the beehive and sell it as a postcard or a bridge or some other architectural structure. So that's what this case reminds us of. And it's just a little bit of an unusual exception based on the type of art itself. Now, other parties might want access to your work in ways that aren't exceptions, and you've got the power to give them a license or a contract or an agreement. So to give them permission to do what is solely your right. And I'm going to just say this. I'm not going to talk about contracting today. There's lots of other things to talk about in that contracting space, but I'm going to say this. Put it in writing. A contract or agreement, the piece of paper, is worth nothing. What it is the written evidence of an agreement that you've made with somebody else. It's going to outline the relationship between you and the other party. It's going to hopefully outline who owns the copyright and the work. And it's going to outline what each party expects to have happen with that work and where the rights will end up eventually. Put it in writing, because most of the people that I speak to on a daily basis have issues because they didn't do this, and so things are unclear. Okay, that was a lot of information, and we're almost at the end here. I wanted to spend, actually, let me just say this. Hopefully what you can see now is how copyright exists all the way through this whole cycle of creativity, from creating the work to others being able to use it, and and then being able to use it inspires or feeds that creativity, and then around that circle we go again. But creative rights really lurks in the background until it has been infringed on. And I'd like to take the last few minutes just to talk about infringement, how to spot it, and maybe what to do. So it's not often that we use the words copyright infringement. It sounds very formal. Often it's known as a breach or one of these other colorful terms, but it means the same thing. It's using a copyrighted work without permission, and it's always going to be emotional, and it's always going to be controversial. Our identity as artists and our sense of self-worth are so invested in our work that these infringement disputes can be really distressing. To add to the distress, infringement disputes have to be taken on a case-by-case basis. Everything is nuanced, so it's not as black and white as, say, a speeding offense. So I know when I pass that speed sign, I know if I'm speeding or not. So there's no, there's a clear mechanism right there for determining whether you've crossed that line or not. But every infringement case is fact specific. So while we're looking at other legal decisions for guidance and for precedent, every situation is going to be assessed on its own unique facts. So let's talk about whether we can decide, or how do we know we've got an infringement case? If you want to determine infringement, or if you think somebody's copied your work, you have to look at these 3 aspects. Number 1, who owns the copyright in the original work? Hopefully it's you, and hopefully you can prove that. I'll say more about that in a second. Number 2, proof of access. It's really hard to prove that I copied your work or copied your painting that you've got hanging on the hallway of your house if I have never been to your house. So it's really hard to prove that copying has occurred if we didn't have access to the work. So you have to be able to prove that there was a point of connection where there would be somebody being able to access your work. And number 3, was the use unpermitted? And did somebody do some or all of the 4 Ds to that work, and was it outside of the exceptions? Now, one thing to know is that coincidence does happen. There are about 2 million songs, about 22, I think it's 2 million books and 22 million songs, or countless pieces of art, lots and lots of film work that are put out every year. And unless we can satisfy these 3 proofs, similarity doesn't prove infringement. So you can have, and I've seen this before too, very, very similar works that come out at the same time. And unless you can prove this, we don't have it. We don't have infringement. How do you prove copyright ownership? In most cases, it's pretty straightforward, but this is a warning story right here. In this case, the artist live streamed their painting of the work that you see on the left on Twitch. Before they were finished, that took them about 8 hours or so, somebody stole the image or screenshot it and then used novel AI to finish it and posted what you see on the right on Twitter about 6 hours before the artist had finished their work, and then claimed that they were the original artist and that the artist was copying them. Now, some creators destroy all of their sketches and early drafts and so on, thinking that if you've got a finished product, that's going to be enough to claim ownership. That might be true in some cases, but sometimes you're going to need to prove that the origin of your creation was before someone else's, so that we can determine who owned the original work. So in this situation, if it was a copyright infringement court case, what would be helpful to confirm ownership is that the artist on the left would have kept backup streams of their work, and those time-stamped backups would have predated the AI image creation. And it's the same in real life. So that's why we need to keep our dated original drafts of our work, especially if we're introducing new elements at some point. So being able to prove your copyright ownership or the creation of your work and that you did it independently is a key part of showing that there's been a copyright infringement. Number two, proof of access to the original work. We talked about Ed Sheeran already. In this particular situation here, Sammy Switch's lawyers spent a lot of time trying to prove that Sammy Switch had sent Ed Sheeran copies of his song, and trying to prove that they opened up those files, listened to those songs, and then deliberately copied them. They weren't able to do that, and so Ed Sheeran won this particular case. And he keeps winning because independent creation is a complete defense. So if it can't be proved that there was access and action, there's no copying, and so there's no breach. And this is why two songs can exist in the same world at the same time, because of coincidence. It doesn't have to be direct, though. This is slightly indirect proof of access. Clayton Hagen is the photographer and videographer who created the character on the left that you see to shoot a pitch film. So he posted pictures of what you see right here on his Instagram, and he created a calendar to raise funds to make a feature-length film. Clearly, he's the owner of the original material. Now, Activision created Mara, who you see on the right there, a character for Call of Duty. And Mr. Haugen sued Activision for copyright infringement of his photographs. So where's this proof of access? How do we know that? Activision copied his work? Well, it turns out that Activision hired the same actress or the same model. They had her in the same wardrobe, and they hired the same makeup artist, and they instructed her to style the model in the same way as Mr. Haugen's project originally. So pretty clear access there. It's a little indirect. We can't prove that Activision actually looked at it from saying, okay, you definitely looked at it, but by the way that they have created Mara, it's pretty clear that they did. This case was settled out of court, just so you know, but I think if it had gone to court, we've got a really strong proof of access. Evidence of infringement. I'm just going to mention this one here. What we're looking for is, have the 4Ds been done? Is it outside of the exceptions if permission wasn't given? We had to think about whether it's transformative or not, right? In this particular case, which is very current and about to go before a jury, this is a kind of a new twist on something. The tattoo artist, Kat Von D, is being sued by the photographer, Jeffrey Sedlick, for her use of his photo to create this tattoo. So this is going to be pretty interesting. So we're going to find out whether this is an exception or not, because the nature of it could be different, or the purpose of this copying could be different. We'll have to find out. We don't know just yet. So if we talk about this next year and it's being solved, I'll be able to give you the answer or the end of it. I said I'd pop back to this case, and I see we're at time, but I'm going to finish up with this case and then one other point. We're talking about whether this was a copyright infringement or not. So in this particular situation, when photos were taken in the 1850s, the tamoko were diluted or erased from those images in the developing process. Now, just recently, over the last few years, photographer Michael Bradley refined a technique to reprocess those photos And that process visually reestablished the tamoko, so you could see them again in the photographs. And he created what was called the Puaki exhibition, and that displayed the original photos alongside these newly processed ones. Now, a tourist artist traveled around New Zealand and went back to Germany and painted the colored image that you see on the bottom right. So is it copyright infringement? So proof number one, who owns the copyright? Well, clearly, Mr. Bradley, as the creator of the new photographs, owns the copyright in them because the old photographs were already out of copyright. So he had the right to do what he wanted to do with those photos. Proof number two, was there access? Well, from the artist's caption, the artist indicated that he traveled through New Zealand and he visited museums and so on. So there's proof of access right there, it's indicated. So we've got to look at proof number three. Was it an exception? Was some of the 4Ds done to it, or, how was it done? Because obviously he didn't get permission, didn't ask for permission. So if Mr. Stritzel had used this photo as a reference to understand shading or shape, or if he had, copied it to develop his technique as a painter for his private study or research, that would be fine. If it had remained in the studio or destroyed, that would have been fine too. We learn our art by imitation, by walking in the footsteps of the masters, and that's totally an acceptable practice. But by his own words, the artist seems to indicate that the thing that has been copied is the tamoko, and that could be considered the substantial part of the original photographs, because that was the point of the original photographs, was to show the tamoko. So that's D, duplication and substantiality are both there. It could be considered derivative in that it says the same thing. It has the same kind of message. He said in his caption, "My passion is to paint people and cultures. I found the contrast between tradition and modernity fascinating." And that actually was part of the point of the Puaki exhibition. So it could be considered derivative. Without question, it has been displayed. It was displayed on Instagram. And then he listed it for commercial gain or for sale on Etsy. And so that's considered distribution. So we've got some of our 4Ds there that are undeniable and questionably all of them. So the legal team representing Mr. Bradley and Mr. McLean wrote a cease and desist letter on the grounds of both copyright infringement and cultural significance. Now, if further legal action is needed, a legal team in Germany, because that's where the offense has taken place, would have to be retained, and that's where the case will be heard in court. Now, I can't tell you if they'd win, but what we see here is this evidence of potential infringement, the proof of copyright ownership, the proof of access, and unpermitted use outside of exceptions. And then we've got that layer of cultural story sovereignty that might add to the emotional distress. And it's the same process, no matter what creative or artistic discipline you practice in. It all falls under the same basic copyright infringement process. So if anything goes to trial, the court's going to look at those three proofs, and then decisions will be based on the evidence and the interpretation of the copyright law in whatever country the offense has taken place. And you can see now why it really falls down to the ability of lawyers to prove this use, the use as being unauthorized and outside of exceptions. So I just wanted to finish with this one last thing here, because this is very particular to us in New Zealand, and it has just been ruled, it's the last court case that we've had on this particular subject. In this situation, Serpa is the artist, and she lives in the Marlborough Sounds. She and her husband split up. The district court ruled that all of her art and the copyrights went to her, and the court ruled that, so all the copyright went to her, and her ex-husband could keep anything that she wanted to give him. Now, he appealed that court decision, and it went to the High Court, and the High Court judge overruled it and said that based on case law from overseas, copyright of an artistic work is relationship property, and property law requires property to be split equally. So Mr. Palmer should be awarded half of the works with their copyright, and that would allow him to make copies and sell them for his own income. Now, Serpa has been given the right to appeal, so this case isn't over yet, but it's a real shock to us in the creative community. The law didn't protect the artist the way we thought it should, but this case absolutely reinforces a couple of things. Number one, copyright has real value. Now, we don't know how this case is going to turn out, but we are reminded that our work output and our creative rights need to be considered as personal property and included in legal documents like wills and trust deeds and prenuptial agreements and so on. So I run a little bit over, but hopefully now that you see the sign, we've got a little more understanding about your rights as a creator, your privileges that there are for users, and copyright infringement, and what that really looks like to strengthen your own business practice. And I will stay on. We can probably stop recording shortly, but if you ever need to get a hold of information about copyright, or if you want to get a hold of me again in the future, you can go to this page right here. If you have a much more difficult question about copyright, use the get in touch form, and it'll go to whoever is most able to handle your questions or your you know, your concerns. So I will open up now if we have any questions, and please don't think anything is silly. I'm not going to give you legal advice, but I will speak out of my knowledge and my experience. Please don't think anything is silly. I've done this workshop over 100 times, and every time there's a different question. So